feeling grow.
Right, so we're going on the record in the matter of the city of Wyandotte versus Travis Allen, 231462, and appearance before the people, please.
Good afternoon, Your Honor. Billy Jo Taylor, P number 82278, on behalf of the people, city of Wyandotte.
Thank you.
Your Honor, Bill Colovis on behalf of defendant P38434. Thank you.
Thank you. And your name, sir, please.
Travis Allen.
Okay, thank you. All right, so we picked the jury. Everyone's had lunch. You're not going to fall asleep because you're too full, right?
No, we're good.
No, it should be an interesting testimony. That should be what the response is. Okay, so we're going to start with opening statements, right? Anything that we have to address before we bring in the jury?
I think you went through all the pre-jury instructions.
I did. You said you were satisfied.
Yeah, right.
Okay, we're good.
Covered it all.
All right, all rise for the jury. Are we doing a mutual order of sequestration at all?
Right, absolutely.
All right, the court will indicate there's a mutual order of sequestration. The witnesses are not to watch any of the proceedings or be in the courtroom during any testimony. Okay, so we are going to, as I indicated in jury instructions, that the people will start with their opening statement and then we'll go from there. So, Ms. Taylor?
Good afternoon. Hope you all had a good lunch. The defendant in this case is charged with disorderly conduct which occurred in the city of Wyandotte. The city will prove beyond a reasonable doubt that on June 16, 2023, at approximately 2:07 a.m., the defendant was guilty of disorderly conduct at the location of the Dot Pub at 116 Oak Street. The evidence will show that the defendant caused a disturbance, did breach the peace, and did gather with others to annoy or disturb others. Thank you.
Okay, Mr. Clement.
Thank you, Your Honor. We don't, as the court set us up, we don't have to make an opening statement that we're approved. We can reserve it and I choose, I guess just being a lawyer and representing somebody, I got to stand up and say something after somebody says something about me. Fine. The proofs, I think will show, pretty sure, in my opinion, when we get done with the case, I think all of you are going to say, why are we here? What are we doing here? That's what I think the proofs will show. I think the proofs will show that there is no criminal action, criminal act that somebody go through the criminal laws, everything that goes with it before and after. I think the proofs will show that there is no criminal wrong that was occurred. All of you are human, all of you have lived life, all of you have been to a restaurant or a bar, all of you have had people make snap judgments on you that may prove later false. Sometimes we don't get an apology, but false. And all of you, I'm sure the proofs will show, all of you, I'm sure, have seen one-sided stories. And the proofs will show that's what this is, one-sided story. I think you're going to sort of like shake your head or say, one, why are we here? Number two, this is not criminal wrong. And number three, why are we wasting energy and resources being here, having everybody here, having a trial, having all this, and there's much more important things to do, to cover. And I truly feel that way. I don't stand up and just start talking and I don't have anything else to do. To reach this stage, there's definitely impasse. I don't blame or fault. Very nice person, the prosecutor, very nice. I've known her for years. I don't fault her. She's a prosecutor. The police are the ones that initiated this. Wait to hear all the testimony. Wait to, more importantly, see and hear all the testimony. The proofs are shown through a body camera. It's not right what happened. And you'll see. I promise you will see. Thank you very much.
All right, people may call the first witness.
People call Tyler Millward. I believe he is in.
Okay, and then Ms. Taylor, you can adjust the podium so that it's facing towards the witness stand. Watch the cord there, please. If you can please have a seat and then state and spell your first and last names. And I'm going to have you speak directly into the microphone. Okay. So you're,
Tyler Millward,
okay.
TYLERMILLWARD.
Okay, thank you very much. Is that picking up okay, Donna?
Yes.
Okay, very good. I'm just gonna ask you to please keep your volume up, okay, please? All right, thank you. And also, please wait until after the prosecutor is done, and even Mr. Clovis, when they're done asking the question before you start to answer. Our recording system can only record one person at a time, and if more than one is speaking, then it's a mess for the court recorder, okay, please? All right, and Ms. Taylor, you may proceed.
Mr. Millward, how old are you?
31 years old.
And could you tell the court where you are employed?
Dot pub,
How long have you worked there?
since about 2015.
And what is your job duties?
I'm a bar back and a door guy.
Door guy, when you say door guy, does that include security for the bar?
Yes,
And when you say security, is that more like a bouncer?
yes.
Thank you. On June 16th, 2023, around 2 a.m., were you working at the Dot Pub that night?
I was not.
Were you present at the Dot Pub?
Yes,
So you were there, but not in an employee capacity, but as a patron that night?
yep.
Okay. How long were you there?
I got there about 11:30 midnight-ish.
Did you come in contact with the defendant on June 16th, 2023?
Yes,
And the person that you came in contact with, do you see him in the courtroom today?
yes.
Can you point to him and identify an item of clothing that he is wearing?
Yeah, it's wearing a.
We'll stipulate, Your Honor, to my client.
Okay, the court will stipulate to the identification of the defendant.
Thank you. Was the defendant with any other persons that night?
Yes, he was.
How many people was he with?
Just one other male.
Would you elaborate to the court what the defendant was saying that night in front of the bar?
He was threatening patrons on the front patio, saying he pays the bills at the bar, stuff like that, right? How much money he makes.
Was he out of his vehicle or was he sitting in his vehicle?
He was saying it while he was on the patio, and then he was saying it in his friend's vehicle. He was in the passenger seat.
Okay, well, let's go back. When did you first have contact with the defendant?
It's probably about 1:30, 1:15-ish, probably 1:30, 1:40. Morgan did last call at 1:30, and they came to the bar to store Catherine for beers. So she took their beers and kicked them out.
Was that inside the bar or outside on the patio area?
One of them was inside the bar, the other was on the patio. So she took one from the inside the bar, then the other one from inside the patio.
When she kicked them out of the bar, where did they go?
They sat in a truck literally right in front of the bar.
Did they have their windows down in the truck?
Yes,
And you said they were yelling at the patrons out front?
yes.
Could you elaborate more on what they were saying to the patrons?
They were just, running the house, talking about fighting people and stuff like that.
Would it be fair to say that the defendant was annoying the patrons that were
Oh,
there?
absolutely,
Would it be fair to say that the defendant was disturbing the others at the Dot Pub?
absolutely.
Was the defendant breaching the peace of the others that were there?
Yes,
At some point, did someone from the Dot Pub call 911?
yes.
Okay. Do you know who did call?
Morgan, the bartender.
Your Honor, we did stipulate to having the 911 call play, but I would like to call that before we bring in my next witness. I'll let Mr. Clovis cross-examine first, unless he wants to play the 911 now.
I'd like to cross-examine.
Okay.
Okay,
Thank you, may I, Your Honor?
yes.
Thank you.
Okay, sir, you're a Tyler Millward, am I correct?
Yes, sir.
Okay, and you're 31 years old, correct?
Yes, sir.
And have we ever talked? Have you and I ever talked?
No, sir.
Okay, have we ever met
No, sir.
prior to this moment, I mean, this? Okay. Now, have you ever talked to the prosecutor?
Not until today.
You've never talked to her prior to?
I've talked to her on the phone, but not in person.
Okay, well, when you talked to her on the phone, when did you first do that?
I'd have to look at my phone to give you an exact time, but it was probably about a week or so ago, 2 weeks ago.
So 1 to 2 weeks ago, you talked to her on the phone? Can you discuss what your testimony would be?
No, we didn't talk about testimony until today.
Okay, what did you talk to her about 1 to 2 weeks ago?
About the incident and asked if I would come to court for it. I
Okay,
was on a subpoena.
all right. And then you talked to the prosecutor today?
Yes,
That was that in person or by phone?
that was in person.
And was it in the hallway? Was it in an office?
It was for a couple minutes in her office, yes.
Do you know, was I in the office with you?
No, sir.
So was it just you and the prosecutor that talked in the office?
Yes.
And you discussed what your testimony was going to be today, what you're going to say?
She just went over a couple questions she was gonna ask me, that was it.
Okay. And then, once that was done, then you left her office, correct?
Yep.
Is that yes?
Yes.
Yes, sir.
Oh, go ahead. You're just a little faster than I was.
Now, you said that you have 2 positions at the dock pub. Is that correct?
Yes, sir.
Okay, you're a bar what?
A bar back,
What's a bar back?
stock the coolers, keep the ice pole,
Okay,
sweep the floors, paint in the night.
I'm sorry, please continue. And
I'm
then,
sorry, I didn't understand what you said.
I think they just clean up the bar at the end of the night.
and then you're a door guy? I'm just
Yes.
looking at what I wrote down.
Yes, sir.
Okay, and it's a door guy. What is a door guy?
Check IDs, basically just sit at the door and if people get out of line, get them out of the bar.
Okay, all right. And if people get out of line, do you immediately call the police or do you escort them out and they leave?
I try to talk to them and calm them down and get them to leave first. But if that does not work, then usually the bartender will call the cops.
Okay. And are you certified by the state of Michigan to be alcohol?
TAM certified?
Yes.
Yes, sir.
Are you certified at all with training with regard to being an escorting people out?
No, sir.
And what bars have you worked at prior to this bar?
I work at Captain's, in Dot Pub, and I worked at the old Chad's Bar, when I was 20.
Okay, and Captain's, do you still work there?
Yes, sir.
Do you have any other job other than the ones you just stated?
No, sir.
And on the night of June 16th, you were employed by the Dot Pub, am I correct? You were not working.
No, I was not working, no.
You were there for your own pleasure, right?
Yes, sir.
Okay, were you there with friends?
Yes.
Okay, and how many friends did you have at one time sitting at a table?
We were never really sitting at the table, we were just sitting at the bar, but my sister was in town from North Carolina,
So
so there was 5 of us.
there's 5 altogether. How many males were there then?
Just my sister's boyfriend.
So it would have been 2 males and then 3 women?
Yep.
Yes.
Yes, sir.
Only reason I'm correct, if I don't, the judge will, it's the reporter has. Thank you. You were drinking alcohol that night?
Yes, sir.
Okay. And where did you first start drinking alcohol that day?
Dot Pub,
And what time did you get there?
around 11:30.
And where had you been prior to?
At home?
So you were at home. Did you have anything to drink at home?
No, sir.
So at 11:30, you went up to that pub where you normally work. You were off duty.
Yes, sir.
Okay. And what were you drinking that night? Alcohol? Were you drinking beer, shots, drinks?
Seltzers, high noons,
What do they call
high noon, so vodka, drink.
it? Okay. And, how many would you say approximately you had?
Probably 3 or 4.
And then, I don't know much about the alcohol, but I'm just gonna rely on you a little bit. Does it come in a can? So it's like a seltzer that you see that's sold at 7-Eleven or something?
Yes, sir.
Okay, and what is it like? Is it like an 8 ounce or 10 ounce?
12 ounce.
12 ounce, like a beer?
Yeah.
Okay. And, you had 3 or 4 of those, and then, do you know the alcohol level or anything like that? What they are?
I believe they're 4.8 or 5% right around there.
A little bit higher than a beer?
It's the same as the beer.
Thank you for educating me. Do you agree that somebody that's been drinking alcohol, that it would impair their judgment at any level, than somebody that hasn't been drinking alcohol?
Well, it all depends on how much alcohol you drink.
Let's say if they had 3 or 4 of these drinks that you talked about, within 3 hours.
Are we talking about a 200-pound man or a 120-pound woman?
Somebody that's like a 200-pound man, you've worked the door and stuff.
I would not see that as impairing them. No.
So you would see a 200-pound man in your experience of working security in the door, a 200-pound man drinking 3 or 4 within, let's say, 3 hours, they should operate an automobile.
They should be able to, yes, sir.
You know how many drinks on the average dissipate out of a bar per hour, 12-ounce drinks?
What was the question, Drew? I'm sorry.
Do you know how long it takes on the average for a beer, 12-ounce beer, dissipate, leave the alcohol system of a human body weighing approximately 200 pounds?
That's 45 minutes to an hour.
I think it's more like an hour, but I may be wrong. And you were there for 3 hours. What was happening approximately? In your stating you had 3 or 4 drinks, right?
Yes, sir.
Did your group at all, did you guys have any shots or anything? They were in town?
No, sir.
Are any of them here today?
No, sir.
Did any of them want to be on video to be able to testify today, do you know?
No, sir.
Did,
I'm sorry, is that an answer to the question, or is that, do you know that?
I have no idea.
Okay,
Sorry.
that's okay.
the last call was at 1:30 approximately, am I correct?
Yeah, around 1:30, yeah. Yes, sir.
Okay, do you know when my client, you're stating my client came in the bar with a friend of his? What time would have that been?
After 1:30.
It was after 1:30,
Yes.
okay? And you're saying that he came in with a beer or drink from right next door, Captain's,
They had
correct?
Budweisers in their hands, sir.
Okay, and was he asked by the personnel, of the bar, to, return those or put those down?
Morgan grabbed the beer out of the one man's hand right away and said, "You cannot have these in here. I did not serve these to you. You cannot bring outside alcohol."
Okay, and then what happened to the other, gentleman that had the beer?
He was on the patio.
Okay, did somebody go out there and say, listen, you can't bring in beer from right next door?
Morgan did that, yes.
Okay, all right, and is that my client?
Yes, sir.
Okay, and, did either one of those 2 individuals want to buy more beer, or were they content with those beers being taken?
Oh, they wanted to buy more beer.
Okay, and it was last call, so they're not selling anymore, right?
Yes, sir.
Okay, and then, did anybody in your group start saying any profanity or derogatory type language to my client and his friend?
Well, that was started by your client, sir, and then yes, it went back and
The
forth.
question that I have is, did you or your group use any derogatory or foul language at my client being on the premises? Is that a yes?
On the premises, sir?
Yes.
No, sir.
So my client and his friend walk out of the bar, am I correct?
Yes, sir.
Last call, no serving, turned in their beer and left the premises, right?
They didn't turn in their beers, they were taken, sir.
Taken, okay. And they left the premises, correct?
Yes, sir.
Okay. And then they went out to their car, am I correct initially?
Yes, sir.
And is it like, is it a truck or something like that?
Black F-150, sir.
A 150? Okay, and that, and you have to speak up, that vehicle was parked directly in front of the barn.
Yes, sir.
Okay, and my client was a passenger, correct?
Yes, sir.
And then the other, his friend, went into the driver's seat, is that correct?
Yes, sir.
And both closed their door, correct?
Yes, sir.
Okay, now, did there come a time that, patrons or yourself or your group went outside and started using vulgar language at my client?
Yes, sir.
Okay. Were you cited at all for disorderly?
No, sir.
Well, you were using vulgar language outside. Don't you think that that is disruptive? Using vulgar language?
No, sir.
As long as you use the vulgar language, it's not disruptive. Am I correct? You agree? Well, then please explain it to me and the jury as to why you can use vulgar, intimidating language to patrons that just left, and it's okay for you to do it.
Well, that's not how it was started. We were being yelled at and sworn at first. He started with the vulgar language, and they were just reciprocating it back.
Okay, and what type of what kind of language were they using back? Please let the jury know this.
sir.
Hold on.
Use better question.
Hold on, one, excuse me,
Thank you, Judge.
one person at a time. The question was, would you please say the language? And I think that Mr. Millward was trying to clarify what language, so, I think that was.
I'll withdraw it.
He appeared to indicate he was unsure of what language you were referencing, so if you want to clarify that,
Certainly.
okay.
Thank you, Judge. Sir, what type of language is being used at my client when it was spoken by you or your family friends? What did you hear? And please be honest and let them know what's going on, because the jury wasn't there that night.
Oh, absolutely. Just going on back and forth about arguing about how he makes so much money, and it was more making fun of him than it was anything really vulgar.
Okay, now you stated earlier that you used vulgar language, intimidating language. Is that correct? You stated that earlier. 5 minutes ago, you said you used vulgar language or your party used vulgar language.
The patrons use vulgar language. I never used any intimidating language.
Okay, well, what type of vulgar language was used by the patrons that you're in charge of? What type of vulgar language?
I want to object.
Okay,
He was not.
what's the objection?
Relevance, he was not working as an employee then.
Okay, please stand up and say it.
I'm sorry, Judge.
That's okay.
Relevance, since he was working there as a patron and not as an employee, I think we just need to be clear.
I would agree that he was a patron that night. He was.
So nobody, he wasn't in charge of anybody.
No, I understand, Your Honor, I agree. But what type of language did he hear?
I understand that, but the end of your question was from the people that you were in charge of.
Right.
So I think that.
So I'll withdraw that part of the question.
Okay, so the question's withdrawn. Thank you.
Could you please tell the jury, quite simply, what was the language that was used? We weren't there that night.
Do you just want me to say words?
I want you to say the words that were vulgar and not nice.
It was a back and forth spat.
I understand that, but I want you.
Okay, excuse me. I'm going to
Instruct.
move this along specifically. Mr. Millward, the attorney asked you a question based upon what your testimony was of vulgar language that had been used. So he's asking for you to repeat those words. That the words that were said, the testimony that you've already indicated was that you did not say those words. You may not feel comfortable having those words on the record, but you testified that vulgar words were used. The attorney has asked you what vulgar words they were, so please answer the question specifically.
Like, you're a bitch, you call,
No, I want to know.
oh, just,
It's not
just.
Hold on, stop, counsel, stop. You asked what the vulgar language was. He's testifying what the vulgar language is. The first one is you're a bitch. He's getting to the other ones.
I asked him what vulgar language he used or his party used, and then he says, then he started to talk about it.
Hold on. The question you asked was what vulgar language was used. Mr. Millward has already testified that he didn't use any vulgar language, that patrons used vulgar language. So he's answering the question about what vulgar language was used.
I will withdraw my question and ask a new one.
Okay,
Okay. What
question
vulgar language,
withdrawn.
what vulgar language was used by patrons in front of you?
You're a bitch, why don't you just leave? I mean, that's about it. I mean, I don't know how much.
Did he ever use, shall we say, the F, did anybody ever use the F word of a patron?
Sure, someone probably said fuck you bitch, something like that.
Do you think that's proper language to use?
Uh,
I just asked you a question.
No,
Do you think
sir,
it's
no,
proper?
sir, no, sir.
Do you think it's disorderly conduct to use that language?
With our First Amendment right, I'll say no, sir.
So people are allowed to use that language as a First Amendment right in your opinion, correct?
Yes, sir.
Do you have an idea why we're here? You have any idea? If you don't, you don't. You just said First Amendment right to use that language. Do you know why we're here today?
Why are we here today, sir?
I'll withdraw my question. Did you hear what the officer said to my client?
No, sir.
Did you ever hear the one officer that was swearing at my client?
Sure he was, sir.
Did you ever hear him swear that night? The officer that was arresting my client, did you hear him swearing, the police officer, at my client?
Not that I remember, sir.
Did you ever see my client try to run from the scene? That's a yes or a no.
No.
Did you ever see my client try to resist any arrest whatsoever? A yes or a no?
No.
Any redirect?
Yes, Your Honor. Millward, you indicated, you testified that you were there with your family on June 16th from out of town, is that correct?
Yes.
Before you went to the dot hub, or while you were there, did you have anything to eat?
Yes.
Did you have dinner before you went, or did you eat at the pub?
We had dinner at home.
So would you say that your judgment impaired at all with this incident that occurred on June 16th?
No.
No. So the 3 or 4 drinks you had and the food you ate didn't impair your thinking or decision making?
No, ma'am.
That's all I have, Your Honor.
Just one or two questions, Your Honor, if I may.
Okay,
Thank you. You're stating that your judgments, or looking in the mirror, if you're drinking, that your judgment wasn't impaired, is that correct?
Yes, sir.
Isn't it best a third party to make that decision, somebody other than you? Could be a better party, right? To see if you're impaired.
What's the question?
Wouldn't you agree that somebody other than you make that call, whether you're impaired or not, looking at you?
I'm still confused with that. What's the question? Like, where do we, who
Well,
would make that decision? Who would-
okay, just a moment. There's not a back and forth. Counsel, I don't,
I'll withdraw the question.
okay.
And I think you've already said that you agree that you're the one making the decision, commenting on whether you were impaired or not that night, correct?
Yes.
Okay, no other questions.
Any further redirect?
Nothing further, Judge.
Okay, thank you, Mr. Millward, for coming in to testify today. Are we playing the video first?
I don't, he's not direct, I don't think we're gonna need him for any questions.
No, I don't need them any further.
Okay,
This
well,
gentleman,
I just wanted to confirm because you indicated after your direct that you have the 911 to play, but Mr. Clovis indicated he would like to cross-examine Mr. Millward first
Right.
before the 911 was played. So that
He never made-
led me to believe that you still needed Mr. Millward here while that was being played.
We do not.
Yeah.
He never made the call.
He did not make the call, just so we're clear, Your Honor. I just want it played before we call the first officer as to why he was called to the call.
Okay. All right. Okay, so Mr. Millward, you are all set, and so Mr. Millward's free to leave?
Yes, Your Honor.
Yeah,
Okay, or you're free to leave, or you are free to stay and observe, whichever you prefer. Thank you very much for coming in. Do not discuss your testimony with anybody. Oh, I'm sorry. Please, just a moment. Please step back, sir. We have juror questions that I do apologize. We have people that Anybody that has any questions from the jury?
How do I ask them? Just.
You have to write it down. For the jury instructions, you have to write them down, and then my court officer will grant them. All right, so Mr. Millward, was it defendant or witness's party that was rude first?
Who first?
Was rude first?
Who's first? The defendant.
Who are the patrons that were using the vulgar language versus non-vulgar?
One of the regulars, Casey Kowski,
Okay,
and my sister's boyfriend.
okay. I think that would be the
Can
sum
we
and
follow up?
substance.
Can we,
Hold on,
I agree
hold on. I
with,
think that'd be the sum and substance of this question,
yes, sure.
of these questions.
Yes,
Okay.
it was.
So based upon those, Ms. Taylor, do you have any follow-up questions?
At the moment, Your Honor.
Okay, Mr. Clovis, do you have any further questions?
Sir,
Based upon these questions only?
right,
Okay,
does your bar have any cameras or audio at all to capture what took place?
There's one camera, I don't think it has any audio, on the outside of the bar.
Oh, right at the outside, so it would have picked up this area?
It should, yes.
Okay, do you have that video for the jury to see?
No, sir.
It would document what took place, am I correct?
Yes.
Okay, no questions.
Redirect.
yes, however, that question was outside the scope, but since that was not objected to, Ms. Taylor.
Mr. Millward, are you in control of the video cameras for the bar?
No.
Did I request the video cameras and the audio recordings if there was any from you?
No.
Would they still be in possession of the owner now?
I don't know what far back they saved. Possibly.
Okay, but it is your testimony they don't record audio that occurs on the patio. That's all I had, Your Honor.
Okay,
Well, just a real quick question, Your Honor. And that is, my client went out to the truck, got in the truck and closed the door, correct? Is that yes?
hold on. The scope is who was rude first and which patrons are using vulgar language, so stick to that scope, please.
This vulgar language was used outside. Is that correct? Is that what
Yes.
you're stating? Okay. So my client got in the car. Your patrons came outside to where he was. Am I correct?
No, so they were already on the front patio.
They're on the front patio. And my client's in his truck as a passenger, correct?
Yeah, it was window down.
And they're on the patio. Are they standing or sitting? Both. Okay. I don't have any other questions.
Anything else, Ms. Taylor?
No, Your Honor.
All right, any other questions from the jury? All right, there are none. Now you are excused, Mr. Millward, thank you.
Thank you.
And again, no discussion of your testimony with anybody.
Yes.
Thank you. All right, the people's next witness, please.
You're going to play the 911 call first, Your Honor.
Yes, and the court will also note that counsel has stipulated to the exhibits. Okay, so let's go off the record for a moment, Ms. Taylor, so you can.
Okay.
All right, so we are back on the record in the matter of the City of Wyandotte versus Travis Allen, 231462. An appearance for the people, please.
Good afternoon, Judge Billy Joe Taylor on behalf of the people, City of Wyandotte.
Your Honor, Bill Colovis on behalf of the defendant.
Thank you, and Mr. Allen.
That's out.
Thank you. All right, and all rise for the jury, please. All right, thank you. All right, you may be seated. Okay, and the people's first witness, please. Second witness, sorry.
The people call Officer Adam Grote to the stand.
All right, thank you. All right, can you please spell your first and last names for the record?
Adam Grote, ADAMGROAT.
All right, thank you. And the council may begin.
Officer Grote, are you employed in the City of Wyandotte as a law enforcement officer?
Yes, I am.
On June 16th, 2023, were you working in your capacity as a law enforcement officer?
Yes, I was.
Were you called by Central Dispatch to the dot hub at 116 Oak Street?
Yes, ma'am.
Were you the first officer on the scene?
Yes, ma'am.
At that time, did you place the defendant under arrest when you first appeared?
Yes, ma'am.
Based on the call from dispatch and what you were witnessing at the scene, from your experience, did you believe that the defendant was attempting to fight the patrons at the bar?
Yes, ma'am.
Would it be fair to say that the defendant was breaching the peace of others?
Yes, ma'am.
Would it also be fair to say that the defendant had gathered with others to annoy or disturb others?
Yes, ma'am.
Would it also be fair to say that the defendant caused a disturbance at the dot pub?
Objection, Your Honor. She's making conclusions that the jury is supposed to. I thought like one or two, but she's to ask questions, and then he gives testimony, and then the jury determines if it fits within the ordinance. Thank you. Conclusions she's asking for.
Okay, your response?
Based on the officer's experience, I can rephrase, Judge.
Okay, yes, because Mr. Clovis had a couple slide through, Ms. Taylor had a couple slide through for you, Mr. Clovis. So, but yes, questions about what led to that would be helpful.
Was all of this captured on your body cam?
Yes, ma'am.
And Mr. Clovis, we have stipulated to play the body cam, correct?
Oh, yes, we stipulated.
At this time, Your Honor, I'd like to play the body cam because the rest of my questions are based from that.
No objection, Your Honor.
Okay, let's try this number 2. Usually, and I will say though that, so let's go off the record for a moment so we can get this playing.
Officer Grote, when you received the 911 call for to be patched to the dot hub, what was indicated to you that was happening?
Dispatch advised me that there was 2 males inside the bar. One was-
Objection, I think the 911 tape speaks for itself. They heard it.
Foundation for further questions, Your Honor.
So, Mr.
State of mind of the officer.
Mr. Clovis, your objection is,
And it's already been testified to, it's redundant.
please stand up.
I'm sorry, I apologize, Judge. That it's redundant, it's already been testified to through the tape of what the 911 call said. He doesn't need to repeat what it said.
And your response, Ms. Taylor?
Goes to state of mind for the foundation of the next questions I have, Judge.
Okay, the court's will overrule the objection at this point, and you may proceed.
Based on the 911 call that you received from dispatch, what was indicated to you?
What was indicated to me was there was 2 people inside the bar, 1 black male, 1 white male, antagonizing patrons, trying to start a physical fight. They had exited the bar, re-entered the bar, and were now sitting in a black Ford F-150 with a given license plate on the front of the bar.
So when you pulled up and seen the defendant exit the vehicle, you were under the assumption from the 911 call that that was the perpetrator from dispatch?
Correct, I matched the given license plate from dispatch to the one on the vehicle in front of the bar. So I immediately knew that was the suspect vehicle.
And when you pulled up, the video does not actually pull out what you were saying back to central dispatch. Do you recall what you had said to them?
Yes, I heard the windows were down in my patrol vehicle. I heard loud, vulgar language coming from the F-150 indicating a fight may ensue. So I told my assisting officers to, lingo is to step it up. Basically, emergency response, we're going to have a physical fight here.
And when you exited your vehicle, you arrested the defendant first. Was that more for patron safety and officer safety?
Yes, exactly. To prevent a physical fight between myself and the suspect, or the suspect and the 4 patrons who I observed on the patio.
And then based upon your further investigation with talking with the patrons and the defendant and the other gentleman in the video, did you arrest him and book him at the police station?
Yes, I did. I was advised that they were threatening people. They brought in beverages, were asked to leave. They refused to do so. They threatened to shoot up the bar, which I interpreted as use a firearm against people at the bar, things of that nature. So we did book them in for disorderly conduct.
Okay. Thank you. That's all I have at the moment, Your Honor.
Alright,
Your Honor, may I?
You may, but just for clarification, was that video, so the 911 tape was People's Exhibit 1, and this video, this body cam video from Officer Grote, Adam Grote, was People's Exhibit 2?
Yes, Your Honor.
Okay, so make sure we had those marked. Okay, thank you.
Okay, officer, my name is Bill Clovis, I represent the defendant. How old are you?
24, sir.
24. How many years have you been in line at police department?
11 months, sir.
So you're still on probation?
Yes, sir.
And you said that you could hear loud language from my client for the truck while you were inside your car, am I correct?
Yes, sir. Loud, vulgar language. Explicit.
We listened just now to the video, the tape of your body camera as you were driving and turning the steering wheel, opening the door. I didn't hear any loud language. Did you hear any loud language?
The speakers on that video right there are not very good, sir.
Okay, so you're saying there was loud language just speaking that.
I just don't know what anybody else heard, sir. I can't testify to what anybody else.
You were in the room. You were in this courtroom.
And I can tell you, sir, I did not hear any loud language from my body camera video.
Okay. And then, did you hear any loud language from the patrons that were standing outside the building?
I wouldn't indicate it as loud as much as I did hear language as I exited my patrol vehicle, which was, we're only out here because you've been trying to fight us. That is what I heard from the patrons.
So what you heard was, we're out here because you're trying to fight us?
You've been trying to fight us as a defensive manner. It wasn't a loud, aggressive tone, sir.
Well, why didn't those individuals go back inside the bar?
I can't attest to what the actions of the patrons were, sir.
Well, you're a police officer, right? Is that correct?
Yes, sir.
On June 16th, right?
Yes, sir.
And you're to enforce the law, the 11 months or whatever, 3-4 months or whatever you had at that time, correct?
Yes, sir.
Okay, and then wouldn't you want to, maybe, if you're gonna arrest people for being loud, arrest those individuals that are talking like that loud outside on the sidewalk instead of staying inside? Didn't you arrest anybody there?
As I previously testified, sir, they were not loud. They were stating you were only out here because you've been trying to fight us in a calm and defensive manner, as in my report, sir.
And you have no idea why they didn't stay inside the building while they were outside, going towards my client.
Sir, I also have no idea why the defendant didn't just drive away.
Okay, and you have no idea why the patrons didn't just go inside.
No, I don't. I have no idea what
Okay.
the actions did.
All right, now, were you trained, how many months were you an officer when this happened? About 3 months?
No, sir. I started in November of 22.
November? So how many months was that?
7 months, sir.
So you were 7 months officer. Were you an officer anywhere else prior?
No, sir.
Okay, and then you go through training in school, is that correct?
Yes, sir.
Is that like at Schoolcraft or somewhere?
Yes, sir. Wayne County Regional Police Academy.
Okay, and then, now, when you arrived, you're the law, am I correct?
Yes, sir.
Okay, and you told the one person that was just sitting in the passenger seat, put your hands on the fucking steering wheel, is that correct?
Yes, sir.
Okay, now, were you taught to do that, or use that language,
Yes, sir.
to say fucking steering wheel?
Yes, sir.
Okay, do you think that's disorderly, disrespectful?
No, sir.
As long as you're saying it's not, right?
It's a technique and tactic and strategy, sir.
A technique in strategies to say, put your fucking hands on the steering wheel. You're real sure on that?
Yes, sir.
There's a department called, is it MyPulse?
No, sir. It's chemicals.
MPulse. Do they authorize that if that got reported? That's okay, you're saying?
Yes, sir.
This is sworn testimony that you can, that's a tactic, that's what you use to the public.
Yes, sir.
Okay,
Dealing with highly intoxicated individuals, they respond only to aggressive techniques.
okay, and sometimes is it physical? Do you get physical with them because that's how people respond?
No, sir.
Okay, you just do it verbally, correct?
I'm confused at your question, sir.
Well, you know, when you went up to the car, you said now, you're saying that that's a technique to say, put your fucking hands on the steering wheel because somebody's intoxicated, am I correct?
No, sir. It's a technique used to see their hands, so I know they don't have a weapon, so I don't get hurt or nobody else gets hurt.
So if you pulled the judge over driving down the street, that's what you tell her?
Yes,
Of course not, right?
because the judge wasn't just a potential bar fight, sir.
Okay, and you're still investigating, am I correct?
Yes, sir.
Okay, and you haven't sat and talked with my client, you just immediately went up there and determined that he was in a bar fight, correct?
No, sir, I did not determine that.
Okay, well, prior to arresting him, the second you arrived, who did you talk to in interview?
I didn't talk to anybody.
Right up to my client, and you put handcuffs on him, you determined that, correct? Immediately, that's what the tape showed.
Did I determine what, sir?
You determined that you're gonna put somebody under arrest without even talking to anybody.
Correct, sir, based on my physical observations of him aggressively approaching a group of people.
And you said his hands in your report were high by his shoulders, right?
Yes, sir.
Did you see that in the tape? Because
Yes,
we'll
sir.
replay it if you saw
That's what I saw on scene and that's what I saw on the tape,
it.
sir.
You saw in the tape that his hands were up ready to fight.
I did not say he was in a fighting stance, sir. I said they were like this.
Oh, okay.
I'm sorry, for the record, that if you can please be more descriptive.
So, in the report, it's going to read, where his hands were raised in a fashion that would be used to disguise a hand strike. Something we learned in defensive tactics was when people raise their hands, it's
Okay.
easier to strike.
Okay, I just wanted to, for the record, because the officer had his arms in a certain position, I just wanted the record to reflect what position your arms were in. Thank you.
And it was open, your hands were open, and they're about as wide as your shoulder, maybe a little wider,
Maybe
correct?
around, yes, sir.
And you were taught
that somebody's gonna hit somebody when they do that.
Not always, sir. Like I said, it's a technique that can be used to easily strike someone from. Disguise, instead of a traditional fighting stance, it can be used to disguise a hand strike to catch somebody off guard.
So you're surmising that the person is drunk, and that's why you said, put your fucking hands on the steering wheel. Then you're surmising that my client is gonna hit somebody because his hands are like this. Is that correct?
I never indicated that.
I'm sorry, and counsel, you're saying like this, so for the record.
Oh, I'm sorry, like you did earlier, where you put your hands up, your hands are up, a little above your shoulder, spread, with, palms open.
I'll answer your first question first, sir. You said I was surmising that
Yes,
the driver was intoxicated.
right.
I never surmised or assumed anything about the driver. I just wanted to make sure he had no weapons in his hands.
Okay, well,
Because he was,
before,
Hold on, please let him finish the next part of the question.
okay, go ahead.
because, of course, he was just in an aggressive altercation in the bar. I wanted to see his hands, make sure there were no weapons. The second questions you were, said was, I was surmising your client may have been potentially going to fight somebody because his hands were up. Yes, I did. He was aggressively approaching them. His hands were in the air. Again, a technique that I learned in the police academy could be used to disguise a hand strike. And yes, I came to the conclusion that he was potentially going to fight somebody.
And you never stated earlier your sworn testimony that you say, put your hands on the fucking steering wheel, when somebody's intoxicated. You never said that earlier. Now let's take out a weapon. They may have a weapon.
Well, yes, sir, it's a little bit of both. There was a bar fight, it's safe to assume, or a bar conflict that they may have been intoxicated, but me saying, put your hands on the steering wheel is not due to them being intoxicated, it's due to them potentially having a weapon. So it's for my safety, for the suspect's safety, who I'm trying to enforce an arrest on, and for the patron's safety.
Okay, did you find out that there was no fight? We had somebody else already testify that there
Yes,
was no
there
fight.
was no active physical fight.
Okay, well, did you, talk to everybody prior? Like usually you separate people, I thought, and you discuss things with each side, then you draw a conclusion and write a report and submit it to whoever prosecutor. Did you talk to both sides first before placing anybody under arrest?
In a secure and perfect world, a secure environment, that would happen. But at the time, again, I concluded that your client was going to start a physical fight, and that's why the arrest was made.
Okay, do you ever go, to that bar? Have you ever been to that bar?
Personally,
Yes.
no, sir.
Okay, have you been to any bar there? The bar next door?
Yes, sir, I have.
Captain's?
Yes,
How often do you go to Captain's?
once every 4 months or so, sir.
Okay, and you drink alcohol?
Yes, sir, I do.
Okay, and then you've never been to the Duck Pub at all, correct?
No, sir.
Is there any reason why you don't go there and you go to Captain's?
I've just never chosen to go there, sir.
No other reason at all?
No other reason, sir.
And did you ever, ask my client if he wanted to bring charges against anybody?
No, sir, I didn't.
Why wouldn't you ask him? Because he would be the only one that was there earlier that you're talking to, right?
Well, sir, my investigation concluded there was no assault, a battery, nothing of that sort, where he was the victim. So there was nothing to have him press charges against someone for.
Okay, well, did you talk to the patrons that were outside? And did anyone tell you that they were using vulgar language outside prior to you getting there?
I did speak to them. They did not indicate to using vulgar language or anything of that sort.
We had one person that usually works there that was off that night drinking there that testified today. Are you aware of him?
What's his name, sir?
Do you have his name?
Tyler Millward.
Do you know that name?
Yep, I referred to Mr. Millward in my report.
Okay, well, he stated earlier under sworn
Well,
testimony.
counsel, I don't think that you can necessarily, indicate to the witness what somebody testified to if we have a sequestration order in effect.
You're right, Judge. But nobody, in your report, you never put that anybody used any vulgar language to my client, is that correct?
Can you restate that or rephrase it, sir?
In your report that you drafted, at the time of this occurrence, alleged occurrence, you never put in that anyone used vulgar language at my client other than yourself.
I didn't put anybody use vulgar language other than your client, sir.
Did you put in the report that you used vulgar language to my client?
No, sir.
Okay, did you say shut the fuck up?
Yes, I did, sir.
Did you put that in your report?
No, sir, there was no
Do
need.
you think that there's no need on your part, correct?
To me, put my own language in there, sir,
Right.
my
It
body
would-
camera collects and captures it all.
It wouldn't look good for your superiors being a few months on the force, for you to be saying, shut the fuck up.
My superiors watch the video, sir.
And you're saying that's proper language for an officer in Michigan to say is, shut the fuck up when he's walking with you.
Sir, at the time, he was continuing to be disorderly and raising his voice, disrupting the peace. There's only one way to solve that, and that's tell them to quiet down. They don't respond to me being passive and polite, then I have to take another technique, which you can see by on camera.
Okay, and another technique would be an assaultive behavior.
No, sir. Assault
Okay.
and verbal is completely different.
Well, we see a lot of things on the world news, so I'm asking you some questions. And you feel that using shut the fuck up and put your fucking hands on the steering wheel is all proper way to handle things, correct?
That's the technique I use, sir.
That's scary. Okay. Have you ever had any complaints against you for your actions in the public?
Not that I'm aware of, sir.
When your vehicle pulled up and it had flashers on, am I correct?
I don't recall, sir.
You don't know if your car had flashers?
Is it equipped with flashers or were they
Did
actually?
you drive that night to this location with blue and red flashers on?
I don't remember, sir. I was right around the block.
You may have been going through stop signs and that without any flashers at all?
Sir, I was right around the block. It was one turn away.
And you don't know if you had red or blue flashers on?
Sir, it was 6 months ago.
I want to ask you, do you remember if you had blue and red flashers on as you pulled up?
Sir.
Yeah.
Counsel, the witness has already answered, he does not recall. Let's move on, please.
You don't recall that, but you recall other facts, am I correct?
Yes, sir.
Was anybody in the group of patrons standing outside flat?
No, sir.
Thank you.
Any redirect?
No, Your Honor.
Any questions by the jury? No. Okay. All right, thank you very much, Officer Group. You may step down, please don't discuss your testimony with anybody. Okay, so let's go on the record in the matter of the city of Wyandotte versus Travis Allen, 231462. And appearance for the people, please.
Good morning, Your Honor. Billy Joe Taylor, P number 82278 on behalf of the people, city of Wyandotte.
Your Honor, Bill Clovis, for the defense. Mr. Travis, please introduce yourself. Travis Allen.
All right, thank you. Okay, and so today is day 2 of our trial. The prosecution is rested. And Mr. Clovis?
Yes, Your Honor, I just want to confirm that the prosecution has rested. I didn't hear her yesterday say that, but maybe I missed it.
She did say that. They said something. Thought I heard. Because
I
then we
can take
talked
that
about.
for my direct. Your Honor, I am going to have one rebuttal.
Okay, right, because then that's when you went on to say, when she said we could start fresh in the morning, we said, oh, I'd like to be fresh in the morning or something.
I knew that, I just didn't know the words.
Yes.
Just rested. Okay.
Yeah,
Your Honor, and then at this time, I would make a motion for a directed verdict based upon the testimony that my client, you could be seated, please. Based upon the testimony that was given, looking at most favorable to the plaintiff prosecution, and that being that there was no fight, that there's if there were any words exchanged, they were words for sure said by the patrons, that these people, that my client, based on the testimony of the prosecution's witness was inside the vehicle, that again, no fight or physical contact at all. Nobody testified that they were threatened. Nobody testified they came into court that felt that their life was disrupted at all. That was hearsay, but nobody came in and testified to that their peace was broken and unjustly so. In addition, the ordinance, city ordinances, when looking at it, is overly broad. It says make noise, doesn't say decimals or what type of noise or anything further by the Supreme Court, that it's just overly broad. Noise, mischief, words like that were nice back in the 1920s or 1950s or 60s. But the courts have ruled, U.S. Supreme Courts, that it's got to be more narrowly construed, so it puts a person on notice of what's illegal and what's not. Somebody to ask to be mischief or disturb my peace. Well, the prosecutor's witness testified that his group was using language and vulgarity, and nothing was done on that part. And I asked him why, and he says, well, First Amendment right. And then if that's true, then, which I think he is, then this case should not go forward. Thank you.
Thank you. Any response, Ms. Taylor?
Your Honor, I would request that the court deny Mr. Clovis's oral motion submitted this morning. Based on the testimony, I believe that it should be sent to the jury for the jury to decide. The ordinance is clear that it states no person shall gather with others for any lawful, unlawful purpose or to annoy or disturb others. I believe that the testimony that was presented in the 911 call, the body cam video, leaves a question to the jury to decide if in fact the defendant did annoy or disturb or breach the peace as dictated in the statute.
Okay, thank you. All right. And the court has heard from Mr. Clovis and from Ms. Taylor. And I think there was some mischaracterization of some of the testimony slightly. However, the court at this point is going to rule that this matter will be for the jury to decide, and the court's going to deny the motion for directed verdict. The court, there has been evidence placed on the record. There's been testimony on the record. And whether or not that testimony rises to the level of a violation of the ordinance is going to be for the jury to determine. So the court's going to deny that motion for directed verdict. All right. And Mr. Clovis, do you have any witnesses to call?
Yes, Your Honor. I'll call my client. Do you want me to wait till the jury comes in?
Yes. I'm
Okay,
sorry.
thank you.
I meant to ask if you had anything else before you called your first witness, but
No, you're
I
not.
clearly haven't had all of my coffee yet, so.
I'm with you.
Okay. All right. And hopefully at 2:20 or whatever time that National Alert System, we will be, maybe at 2:15 we'll take a break. Okay, all rise for the jury. You may be seated. Good morning. All right, and Mr. Clovis, your first witness, please.
Thank you, Your Honor. I call Mr. Travis. I'm sorry.
Good morning. Please raise your right hand. Oh, I'm sorry. Thank you.
I do.
All right, thank you very much. If you can please spell your first and last names.
TRAVISALLEN.
All right, thank you. And then, and just so you know, the microphone does adjust, so if that's not a comfortable position, there you go. Thank you. All right.
May I
And
proceed?
you may proceed, yes.
Thank you, Your Honor. Your name, please.
Travis Allen,
Okay, and how old are you?
34,
And what grade did you complete?
11.
And are you currently employed?
Yes,
And where do you work? How long did you work for them?
3 years.
And what type of work do you do?
I'm a PVC operator for the UAW.
What does that mean?
I make bondos, sealing, the undercarriage spray for the UAW.
So it's connected with the automotive industry?
Yes,
Back on June 16, 2023, this year, did you have occasion, unfortunately, to be arrested?
yes,
Prior to being arrested that day, had you been at home?
yes.
Okay. And do you live alone?
No, I live with my son and my girlfriend.
Okay. And your girlfriend is the mother of your son?
Yes,
And what is your son's name? How old is your son?
he's 3.
And where do you live? And how long have you lived there?
For 6 years now.
And did you work on June 16th, 23?
Yes, I do.
And what would be your shift preceding you getting off?
That day I got off early because if I finish my work, I can't leave. I usually the 10 to 6 shift, I'm night shift.
10 at night till 6 in the morning?
Yes,
Okay, did you take time off to be here today, or did you work last night?
I worked last night.
What time would you gotten off work that day? The 15th,
That day I got off work at 11,
at 11 a.m. or
at 11 p.m.
p.m.?
Yes,
So you went home, I presume, after work,
yes.
or did you go to the bar, or I'm talking about on the 15th?
On the 15th? Oh, on the 15th, I worked and I just went home.
Okay, and you would have gotten home about 11 o'clock at night, because what's alleged is that this happened June 16th after midnight at about 2 in the morning.
Yes.
So the 15th, what time did you get off work?
The 15th, I got off work at 2 a.m.
2 a.m.
Yes.
Okay.
Oh, no, okay, the 15th, I keep forgetting it ran into the next day. The 15th, yes, that was when I got off at 11.
Okay, and where did you go after you got off work?
I went home, I showered,
Okay, and then what?
and Matt was already on his way to meet me, so then I met Matt.
Matt is a friend of yours.
Matt is the other person that was arrested in this case.
Was that, Matt, the, white Caucasian man?
Yes,
Okay, and was he the driver of the vehicle?
yes,
Okay, so he met you, did both of you drive your separate cars there?
no, we both got in Matt's truck.
Where did you meet Matt to get in his truck?
He met me at my house.
Oh, okay, so he came to your house, picked you up, and then he drove.
Yes,
All right, and then where did you go?
we went to Captain's.
Okay, and that's a, bar or restaurant establishment,
Yes,
and it's on Oak Street?
yes,
And where did, what type of vehicle did Matt have?
yes, it's black F-150.
Okay, and where did, Matt drive? That's Matt Bender, is it?
Yes,
Where did, Mr. Bender, park his vehicle?
right in front of the shop.
Okay. And, there's a street there, there's parking along there?
Yes,
And, was there any difficulty in parking the vehicle, or was there any trouble with people in just parking the vehicle?
yes, that's the reason why we parked in front of the dock instead of in a parking lot across the street.
Rather than the parking lot? Why?
There was no parking in the parking lot across the street.
Oh, okay, so, but I mean, there was no trouble in backing the vehicle in or doing anything like that?
No.
Okay, all right. And so then, what time did you say you got, you arrived at, which bar was it you went to first?
Captain's.
Okay, what time did you arrive at Captain's?
That was about 11:45.
Okay, and did you have a, drink there?
Yes,
And what type of drink would have you had?
I had 4 Budweisers.
You had 4 Budweisers?
Yes.
Okay. Were they bottles of beer, or were they, or a glass?
Very nice.
Glass? Okay. And just for the jury, about what size would those be?
12 ounces.
So you're pretty sure you had 12, or excuse me, 4?
Yes,
And Matt also had consumed alcohol?
yes. He drank less than me. I had drank a beer before I left, and then 3 at Captain's. So that's what that was.
Okay, so you stated earlier, and it's very important as the jury is listening and also taking notes, is that you have to listen to my questions and then respond as accurate as you can, okay? So I asked you before, how many drinks did you have there? You said 4. So now you're saying you had 3.
Okay, I'm sorry. I made that. All right. I made a mistake. What I meant was 4 total. I thought he was asking me about how many drinks I had total. I had 3 drinks at Captain's.
Prior to being picked up, you had 1 beer.
One beer.
Okay, and then when you got to Captain's with Matthew Bender, then you had 3 more beers?
Yes.
Okay. And, did there come a time, was there any problems at all at the first location that you were at?
No problems.
Did anybody call the police on you?
No.
Okay. Did, anybody say you created a disturbance, you had to leave?
No.
Was it a nice evening inside Captain's?
Yes.
So, were there a few people inside Captain's, or was it busy? How was it?
It was sort of busy, but it wasn't like super busy.
You weren't on top of one another?
No.
Okay, but would you say it was at least half filled up?
Yes.
Okay, and there were no problems again there, right? And Matthew Bender.
I'm sorry, after that question, I didn't hear the answer.
No,
And Matthew Bender, the person that you were there with that drove, did he have any problems with anybody?
yeah,
Were you having a nice evening?
yes,
Did it look like Matthew was having a nice evening?
yes.
And were you just talking about things, or were you there to meet somebody?
No, we were just there, me and him hanging out.
Okay. And so then, at one time, as I understand, you left that bar, am I correct?
Yes.
Captain's?
Yeah,
And where did you go from there?
we went right next door to the Dot Pub.
Okay, and that's immediately next door?
Yes,
Okay. And does the Dot Pub, do they have like a patio out front that people can sit?
yes,
And people can sit like on a sidewalk almost or patio and drink and eat?
yes,
Okay. And so, did you go there with any beer already in your hand?
I did.
Okay. How much of a beer was in your glass when you walked over there?
It was half full at that time.
Okay, so you had approximately 3.5 beers that evening at that time, am I correct? It was half full.
That beer that I'm talking about was a part of my fourth.
It was your fourth beer.
Yeah,
That you didn't
I walked out with my fourth beer.
for the evening.
Yes,
So you had one at home, then you had 2 more to begin with at the bar, correct? And then there was a third one, and that was still half full when you went next door, right?
yes,
So that would be 3.5 total at the time that you started walking next door, correct?
correct.
Okay. So, did you make it inside, the Dot Pub?
Yes, sir.
Okay. And did Matt make it inside, the Dot Pub with you?
Yes, he did.
Okay. And both you are carrying your own glasses?
Yes,
Was he drinking also beer?
yes.
Okay. So where did you sit in the Dot Pub?
I sat right at the bar.
And where did Matt sit?
Matt ended up talking to a girl and then going back outside.
Okay,
But he
and,
sat at the bar with me at first.
okay. Did you order any other drinks there?
I ordered one beer, but she wouldn't give it to me. Well, she said it was already last call, or it was last call, but she, I guess, because she seen the beer in my hand, she didn't want to serve one more.
Okay, she saw that you had brought a beer in,
Yes,
and so you're saying the lady bartender did not want to serve you.
correct.
Was it also 1:30?
Yes,
Okay, did they announce, while you were in the bar, Dot Pub, did they announce last call or no more serving?
yes, they announced last call, about 5 minutes after we got there.
Okay, and so you didn't end up, for whatever reason that you stated, you didn't order any other drinks, or you didn't get served any other drinks?
No.
Do you know if Matt got served any other drinks?
No,
You don't know?
no, he did not get served anymore.
Okay. Now, there came a point where Matt is talking to a lady in the bar, am I correct?
Correct.
Okay, and that lady, was she with the group?
She was.
That would, let me finish the question. Was she with the group that was spoken of yesterday with the person that testified from the bar?
Yes, she was.
And was Matt talking with her for a while?
Yes,
Okay. And did everything seem okay?
yes, between them and her.
Okay. And did you know at all that she was with this group in the bar?
I had no,
Okay. You just stayed to yourself or with other people up at the bar sitting?
I was up at the bar just sitting, chatting with the bartender.
Did you yell or scream that you wanted to drink or that she said you can't drink? Did you cause any commotion at all?
No, I wasn't even kicked out of that bar.
Okay. Hey, you been there before?
Yes, I had.
And how many times would you say you've been there, let's say within a month?
I've only been there total 2 times.
Okay. Was there ever a problem your prior time?
No,
And did you go at night or in the afternoon or early morning?
I went at night.
Like about what time your prior visit?
That time, we stopped there before we went down to Whiskey's. That was about at 12 midnight.
Okay, and there was no problem that night?
No.
So then, Matt is talking with this female person that's part of this party, correct?
Yes.
Was this group? And then what happened to Matt? Did he stay
I
inside?
was still inside at that time. I didn't see nothing about what happened to Matt until I ended up coming outside.
Well, did Matt stay inside or did he go outside?
Oh, him and the girl, they were outside. They were.
The girl and him went outside.
Hold on, Council, please let Mr. Allen finish the answer before you ask the next question for the recording, okay?
That is correct. I don't want to upset the court for that's for sure. So could you please answer this question? Did you see Matt and the young lady walk outside?
Yes.
And then did it look like there was any disruption when they were walking outside?
No.
Did it look like they were getting along?
Yes.
Okay. And then, what did you do, or what did you see? What did you see with Matt, or what did you do? What happened then, when you walked outside?
The only thing, I didn't see much when I walked outside. I just heard Tyler say to Matt, if you can't afford the drinks, don't come out. And that's,
Go ahead, how did you interpret that?
when I walked out and I heard that, that's why I think he thought I was bragging about my money, because I said, I'm a UAW worker and he's better off than me. And then that's when things kind of escalated from there.
Well, you were outside at the time, am I correct?
Yes, that's when we were going to leave. When everything started happening was when the bar was closing. It was about time to go.
And this Tyler Leonard or whatever, that testified earlier or yesterday, why would he say you can't afford the drinks? Is it because you didn't have the drinks that you bought there? Or?
It's because I didn't see this at the time, but I guess when, like he said, somebody from the bar had took Matt's drink. Somebody took his drink and knew that it was from the other bar. So I guess that's what he was trying to say, like, we can't afford the drinks because we're bringing it from the other bar. But,
Okay. Did anybody take your drink?
no,
Where did your drink end up? Did you
I
drank?
drink.
So you sat at the bar,
Yes.
you finished your drink. Okay, that was beer, correct? When you went to order one, she said,
I think she might have just wanted to close up because it was last call, but she said she did see that I brought it in from another bar.
okay, this is the bartender that works right at the bar where you're sitting.
Yes.
You know, it's like a high bar, right?
Yes.
Okay. And so then after that was said to you or you and Matt outside by Tyler that testified yesterday, what happened then?
He said, you can't afford the drinks, then don't come out. And I said what I said. And he was like, get in your car and let the leave.
So when you said what you said, that was that you said you work for UAW and he makes more money than I do.
Yes.
And what did you mean by that exchange?
He was basically insinuating that we couldn't afford the beer. So I was telling him that's not the case.
Okay. And so then, did you and Matt get in Matt's vehicle or go somewhere else?
No, we got straight into the vehicle.
Okay. And then what were you two planning on doing while in the vehicle?
We were gonna call a Lyft. So
You were,
we're gonna call a Lyft because we had been drinking, so.
okay, so you were gonna call Lyft, in other words, like a Uber or whatever, to somebody to come pick you up.
Yes.
Okay. And prior to you making that phone call, what happened? That led that prior to your arrest?
It was just a little bit of back and forth. Even like the whole night, nobody was really yelling. We had a few words back and forth, and then.
And who were the?
Tyler got a little bit aggressive, but even he wasn't screaming to the top of his lungs or anything like that. But he did get aggressive. He walked up closer to the car, and he was a little aggressive.
Is it because do you know why he was doing that? What he was saying?
He was with a group of girls, and I just feel like he was showing out just a little bit, and he was.
And what type of words were being used to you and or Matt?
Well, he said, he said, you guys are bitches. He said, he won't get out of the car. And he was right about that. We didn't want to get out of the car. We didn't want to fight. We were just trying to have a good time that night. It was Thursday night. I had to wake up and going out of town that next day.
So you heard him say that at least one person said bitches.
It was Tyler. Tyler said, you guys are bitches. You won't get out of the car.
Okay, and did anybody else say any other words during this exchange?
Well, one of his friends, one of the girls, actually walked up to the car, smacked Matt's mirror, started kicking his tire. And that's the only time Matt was like, hey, get away from my car. And that was a little bit loud, but that he just said, get away from my car.
And Matt was in the passenger or driver's seat, correct?
Yeah.
He never opened the car, got out,
Never.
aggressiveness. Did anybody use any profanity type words, racial words, anything like that?
I did not hear any racial words. I definitely heard a bunch of profanity. I heard a bunch of bitches, you gotta leave, this and that, whatever, you know. But like I said, the reason why we didn't go running off right away, first of all, we didn't want to look like we were being guilty or anything. At that time, I did see the girl come out. I seen her get the license plate. I didn't want to look like we were running away from the scene. So we just sat there, and then also we were calling the lift, so, you know, just, you know, drive away. You know, he had a drinking, they got a DUI, and we also looked like we're fleeing the scene, you know, so.
Okay, did you hear yesterday through their witness that there's outside cameras?
Yes.
Okay, you haven't seen any camera evidence at all, have you?
No, I called up there. They told me that they hope to have the cameras for 30 days, and I wasn't able to detain you until after that 30 days.
Okay, so you made a good faith effort
Yes.
in trying to get these pictures or
Yes.
video of the outside to prove what happened.
Yes.
And they weren't, after 30 days, they told you that they don't exist anymore.
Yes.
And what happened after she hit what part of the vehicle was this lady?
She smacked, she like walked by, smacked his front mirror, and then walked to the back and started kicking his tire.
Did anybody do anything about it from the bar?
No.
And so then, did eventually a police officer arrive?
Yes.
Okay. Would it be the officer that testified yesterday?
Yes.
Okay. Please tell us, court, jury, what occurred. You were in your vehicle and what happened?
So I was in the vehicle, and then, so I had already seen the girl, give me the license plate. She, called the cops. I mean, she was. And then I seen his lights flashing. So he did have the lights on, like he didn't remember. They were flashing yesterday, or they were flashing in the rear view mirror. I seen them on the windshield. So that's when I got out the car, and I had it right before that. I had asked Tyler, I was like, if you guys aren't doing nothing, why are you out here next to us? And he was like, that's when he said, if you guys heard it, he was like, we're out here because you're trying to fight us. And when I got out the car, my hands were not like this.
Hold on, I'm sorry, for the record, the record can't see what your hands are doing right now, so if you can,
Explain.
counsel, if you can just indicate for the record, the
Right.
position of, the witness's hands, please.
Why don't you go back and state what you were saying with your figurative way?
Okay, my hands, they were not up by my shoulders like this.
Okay, stop right there. Let the record reflect that the client has his hands with open palms, and it's about 12 inches past his shoulders, each hand, and they're raised about head level.
And when I got out of the car, what I said to him, I was like, but we didn't fight. We weren't trying to fight. I said, we didn't fight you. That's exactly what I said. And my hands were down, and they were out. I was trying to show that I seen the cop. I got out of the car because I seen the cop. Now, when the cop told me that when I asked him what I'm being arrested for, he said, because I seen you get out of the car trying to fight him. That's what I was saying. No, I did not get out of the car trying to fight anybody. That whole night, I never got out of the car trying to fight anybody. Even Tyler said yesterday, we never got back out of the car. I never tried to fight anybody yesterday, or I never tried to fight anybody that day. So.
Okay. And then you heard the officer, I'm not going to repeat the profanity, But you heard the officer use the profanity yesterday, is that correct? Okay, would that be true and accurate of him swearing at both of you?
Yes,
Did you ever swear at the officer?
I did not,
Did Matt ever swear at the officer?
not that I heard.
Well, you were right there.
Actually, they put us on two different sides.
Okay.
Well, they took me out of the vehicle, took me back to a car that's back there, and they took me out.
I want to slow down a little bit for the jury. When they took you out of the vehicle, I mean, we did see a video yesterday. They took you out of the vehicle, what happened next?
Took me right out of the vehicle, put cuffs on me, and I was like, what am I getting arrested for? And then he was like, I just seen you jump out of the car trying to fight him. Oh, I didn't see you jump out of the car trying to fight him. I just seen you jump out of the car.
And then what happened?
And then that's when he took me back and was cuffing me and telling me to shut the fuck up.
Were you trying to say your side of the story of what happened?
Yes,
And he was telling you, shut the fuck up?
yes. I never got to explain anything that.
Did you get a chance to write out your version of the report?
I did not. He didn't ask. No, he didn't ask none of our side. It looked like he came and he had an issue. He wanted to arrest us.
Did it look like he already made up his mind when he was arriving?
All the way, all the way.
Hold on, Mr. Allen, please let Mr. Clovis finish the question before you answer, okay?
Did it look like the officer already made up his mind when he arrived that he was going to arrest you? Is that yes?
Absolutely, yes.
I don't have any other questions.
All right, thank you. And Ms. Taylor.
Are you employed at all with the dot club?
I'm not.
No, you stated you were employed with, just wanted to verify you didn't have a side job with the dot club. On the night in question, on June 16th, 2023, did you know any of the patrons that were at the dot club?
I did not.
When the bartender told you that you missed last call, why didn't you and Matt just leave?
Because me and the bartender actually were having a good conversation.
Is it safe to say that at that time the bar was closing?
No,
No, it was 1:30 when you were there?
yes.
That's correct. Was there anything else open in the near vicinity area?
No.
To your knowledge?
Oh, you talking about as far as establishment?
Yes.
Yes, the next door, cabin was open, whiskey's was open.
And why did you leave Captain's?
We just wanted to change the scenery.
When the officers arrived, let's go back. You testified that you had 3.5 drinks that evening.
4 total.
Well, it's my understanding you said 3.5. You purchased more, but you only finished half.
No, I finished that last half at the dot club.
Okay, so you had 4 drinks.
Right.
When the officers placed you under arrest, did they request you to submit to a PBT test?
They did,
Did you refuse?
yes,
Do you know that Matt did submit to a PBT test?
yes.
And how many drinks did you state he had that night?
I have no idea what that drink.
Your Honor, I'm going to object that may we approach.
So it's my understanding from testimony that was given by Mr. Millward yesterday that the doc took both of your drinks when you appeared at From Captain's.
He said yesterday that she took the match drink.
I'm sorry, well, I didn't hear that.
He said yesterday that she took the match drink. He didn't say anything about her taking mine.
So I think we have a difference in opinion of the testimony. I remember him saying that she took both of your drinks. Did you testify that they did not take your drink?
They did not take my drink. I was upset.
So your testimony is also that you got into Matt's vehicle and you were going to call for a Lyft driver, and that's why you did not leave.
That's one of the reasons.
So you believe at that point you had too much drink, you both had too much to drink to drive?
No, I didn't believe that. I just wasn't driving. I wasn't driving with him. He wasn't going to drive his truck, so my best friend actually died from drinking and driving.
So why did you roll the window down and engage in continued conversation with the?
The window was already.
But you had the option to roll that window up, correct?
Correct.
And you did not?
I did not.
At any time, did you witness the girl hit Matt's truck?
Yes,
At any time, did you or Matt call 911?
we did not. She stopped and said stop.
So you chose to continue to sit there, not call the Lyft driver, keep your window down and continue to go back and forth with the patrons?
this whole altercation didn't last that long, and the cops were there since, so.
So you knew when the bartender called 911?
I seen her in the back, of the, truck with, she was living in Lexington. So that's-
And at that point, you still chose not to leave or call for it?
Yes, I felt it made us look like we're trying to keep the scene.
And why would you think she was calling 911?
Because I just, first of all, like, what was going on, and then I seen her glance at his license plate. I don't even know if she was on the phone, she was a bartender outside.
So you heard the 911 call where the bartender claimed that you were antagonizing and threatening to harm the patrons, correct?
I did.
So you're saying that none of that occurred?
I think when the bartender, she made the 911 call from inside and then came outside. I don't think she even seen what first happened. And also I think that she knew those kids, and that's the reason why she decided to take their side.
So your testimony is you did absolutely nothing wrong.
Yes?
That's all I have, Your Honor.
Any redirect, Mr. Clovis?
No, Your Honor.
All right, thank you, Mr. Allen. All right, any further witnesses?
We rest, Your Honor.
Okay, any rebuttal witnesses for the people?
I do. Sergeant Fitzpatrick.
Does anybody in the jury need a break right now? Good morning. Please raise your right hand.
Yes, I do.
Thank you. You can please have a seat and state and spell your first and last name.
Sergeant Robert Fitzpatrick, ROBBRT FITZPATRICK.
All right, and you may proceed.
Good morning, Sergeant Fitzpatrick.
Good morning.
Thanks for coming in this morning. Just a few questions. How long have you been on the force?
25 years, 2 months.
You started off as an officer and now you're sergeant.
Yes,
Are you a superior of Officer Adam Grove?
yes.
Have you had the opportunity to watch the audio cam that has been presented to this jury?
Not entirely, no.
Okay. Have you watched body cam videos of the officers from incidents that occurred?
Yes, I have.
And do the officers use vulgar language at times?
At times, yes.
Is that part of their training?
Yes, back when I went to police academy, we were taught that sometimes that's the only thing that certain people understand. You can't talk to a career felon who's done most of their life in prison the same way you can talk to a kindergarten teacher that just don't respond.
Officer Grove did indicate through his testimony that this was a training and technique that officers use in situations when persons could be intoxicated. Is that correct?
Correct.
So it's not uncommon to hear on the body cams them using the F word.
No, it's not.
Do you believe that using the F word is an inappropriate action by the officers?
No, if it's used sparingly, it gets people's attention. Some people don't respond to the sir, please do this, sir, please do that. They just don't. I mean, it gets somebody's attention if it's used sparingly. It's very effective.
That's all I have for you. Thank you for your time.
Yeah, Your Honor.
Of course. You get to cross-examine.
Sir, you had just stated that you wouldn't, a kindergarten teacher, you would talk different than somebody that's a career felon, correct?
It depends on the situation, but yes, for the most part.
Okay. Do you know if my client's a career felon?
I have no idea. I don't know any details about this case.
So it's tough to pass judgment unless you know all these facts, right?
Correct.
Okay. And do you think that if somebody's being very cooperative, that you should say, put your fucking hands on the steering wheel? Do you think that would be normal?
It all depends on how many times you ask them to put their hands on the steering wheel and the situation that you're coming into.
If you just ask for the very first time you're meeting him, put your fucking hands on the steering wheel, what do you think about that?
Again, I have no idea what the situation, the call was that they got sent to in the beginning. I mean, if that was it, I just looked at a traffic stop or a speeding citation, I had nothing else to go with, that would be inappropriate. If I got called for a fight or something of that nature, it may be appropriate.
Okay. And then if somebody is talking with you like I'm talking right now, and not resisting or obstructing, would it be proper if they ask you a question and you say, shut the fuck up? Would that be proper?
All depends on the situation. Again, sir, I have no idea. I was not there. I don't.
This is the situation.
You and I talking right now? No, I would not talk to her.
That would be completely wrong, right?
It's not something that I would do.
But you won't admit if it's wrong?
Who am I to judge whether that's wrong or not?
Well, I
I'm just
understand.
saying it's not something that I would do.
Police officers have this togetherness that they protect sometimes one another. Do you agree and not pass judgment?
To some extent.
If I'm on the street, you're in uniform, I came up to you and said, shut the fuck up. What would you do? Would you say, well, Bill, why don't you have a nice day? No, I think you probably almost arrest me right then and there, right?
I would not make that arrest.
Oh, okay, so I can come
That's
up
not
to
the worst
you.
thing someone said to me this week.
Okay, so in other words, I can come up to you on the street and say, shut the fuck up, and you'll tell me, have a good day.
You think that's the worst thing someone said to me this week?
I didn't ask you. I said, if I said that to you.
Yes, I might say have a nice
You
day.
would say, okay, I'm gonna hold you to that.
Yeah, I'm not gonna arrest somebody for that.
You work for the detectives upstairs, right?
Yeah.
Okay, I'm gonna hold you to
Go right
it. This
ahead.
week,
Okay, hold on, stop. We're moving way past and out of the scope. So move on.
now it's talking goofy. Do you know anything about the tape at the bar outside of the tape?
Nothing whatsoever.
Did you investigate this case at all?
Nothing
Past the
whatsoever.
scope, objection, Your Honor.
What are you talking about?
Hold on. Her objection,
My
her,
documents.
counsel, please, let me state for the record, make a record, please. The prosecutor objected beyond the scope. Now, your response.
This is my cross. What scope? I'm examining him.
My question is a rebuttal witness, and my questions were limited in scope.
No, that's just not the rules of evidence. I mean, she asked questions, now I get to ask him questions. Deals with credibility. I don't even have to say why. If it's relevant at all, I can ask him questions. She chose to put him up. If he turns out to be different than what she thought, that's on her.
Well, counsel, there are, within the rules of evidence, there clearly has to be relevance, perhaps, and there, if there's a certain scope within, a certain amount of question, certain type of questions that were asked on direct, as a rebuttal witness, then there is a limited scope within which to cross-examine the witness.
So the court is ruling that I can only ask questions of the areas that she asked, and I can't ask anything
Now,
else.
if you're asking questions to establish credibility, that was one of your arguments,
Yes,
that could be permissible.
okay. And his training and things like that, which would be credibility. Yes.
As far as the training, that would fall under credibility, that would be permissible.
I agree.
But you also need to make sure that you're not going outside the scope of the questions that were asked as well.
So in rebuttal, she can just choose which one she wants to ask, and I can't go outside that. You know, I'll just I'll withdraw the question respectfully, Your Honor, and I'll move on, if I may.
All right, you may move on.
Thank you, Judge. Have you ever had a complaint in the 25 years 25 years and 2 months? Have you ever had a complaint filed by a citizen against you?
Yes, I have.
About how many? If we check the personnel file, how many?
Probably 2, maybe 3.
Would you agree that if somebody's they feel too much to drink to call to call somebody to pick them up if they've had too much to drink, do you advise that not to operate a vehicle? Thank you. I don't have any questions.
No further questions.
All right, thank you. Any questions by the jurors? No, none. Okay. Thank you, Sergeant Fitzpatrick, for coming in and testifying. Please have a special testimony for anybody to the conclusion. Okay. Any further rebuttal witnesses for the people?
No, Your Honor.
Any rebuttal witnesses for the defense?
No, Your Honor, we're happy.
Okay. All right. We're going to take about a 10 to 15 minute break. We're going to excuse the jury. The court will go over a few things with counsel. And then when we resume, we will start with closing arguments. Okay, I'll rise for the jury. Okay, so let's go on the record in the matter of the City of Wyandotte versus Travis Allen, 231462. And appearance for the people, please.
Good afternoon, Your Honor. Billy Joe Taylor, P number 82278 on behalf of the people.
Your Honor, Bill Clovis, P38434, on behalf of the defense.
Thank you.
Travis Allen.
All right, thank you. All right, and so then bring in, you're both ready with your closing arguments, correct?
Yes, Your Honor. You're welcome.
Okay, all right, let's bring in the jury. Okay, thank you. Everybody may be seated. We are going to go right into closing arguments. So, Ms. Taylor?
Thank you, Judge. First off, I want to thank you all today for your last 2 days of service here. It's not always fun sitting on a jury, but we do appreciate your time and your service. The video that has been showed can be disturbing in that how the officers talk to you. I talked to a person, but as the officer and the sergeant testified, this is a standard training and technique of how to deal with persons in these situations. I ask that you take your heart out of it and apply the law to the facts of this case. The law is outlined on the jury instructions that you will receive on page 10, states that disorderly conduct under the City of Wyandotte Code of Ordinance states that no person shall make, aid, or assist in making any improper noise, riot, disturbance, breach of the peace, or diversion tending to breach of the peace. B, no person shall engage in any indecent or obscene conduct in any public place. Or C, no person shall gather with others for any lawful purpose to annoy or to disturb people. Based on the 911 call, the description the caller gave to dispatch of the two guys that were antagonizing and making threats to the patrons of the dot pub, and the description given of the truck parked in front of the dot pub. The officer had a duty to secure the scene when he first arrived. He arrived alone to a scene that had patrons outside and a gentleman that jumped out of the truck. His first duty is to secure that everybody is safe. The defendant jumped out of the truck on the passenger side when the officer pulled up. The officer, based on the information he received from dispatch, deduced that the passenger was one of the persons the caller identified to 911. One can infer that the defendant was drinking and was intoxicated at 2 a.m. The defendant left one bar, left there, went next door to another bar, where they were already given last call. Here the defendant had the choice to leave, since this bar was closing. He was not employed there, nor was he hanging out with any of the patrons. Instead, the defendant chose to get in his friend's truck, which was parked directly in front of the outdoor patio area. He chose to keep the window rolled down. He chose to continue to engage with the patrons. And from the testimony that was presented, when the officer pulled up, he heard the defendant yelling and making threats to the patrons. As my grandmother always said, nothing good happens after midnight. He had that choice to leave. Instead, he chose to stay there. In this case, the 911 call, the body cam video, and the testimony that has been presented clearly show that defendant had gathered with another person and did disturb and annoy others in a public place. You must weigh the credibility of the witnesses that testified to determine who is telling the truth from the testimony that has been presented to you. Therefore, we believe the defendant is guilty of disorderly conduct, and the people are respectfully requesting a verdict of guilty in this matter. Again, thank you for your time.
Thank you, Mr. Fields.
Your Honor, thank you. At the very beginning, just so I don't forget, the prosecution has this burden of proof we talked about earlier. Because they have the burden of proof, they bring the case, as we already know, and the case closes and rests both sides, and then we do closing statement next time we talk to you. And then the judge will read the jury instructions, which is the law. And it's voluminous, but she'll read all that law. And then you collectively sort of are a judge of the facts. Collectively. And the judge, we stand for this. I respect that both of you are an ineffective judge. Also the prosecutor, because they have this heavy burden of beyond a reasonable doubt, they get to talk to you twice. She just got through doing her closing statement. I do one on behalf of my client, and then she gets to do the last one. She has the last word. And sometimes prosecutors or plaintiffs will hold back some stuff, so the other side isn't able to reply to it. So I don't know what she may say, or she may say anything at all. But just keep in mind, what would Bill Kalobis say? What would the defense attorney say in reply? All of you, the court will say you don't leave your common sense at the door. So everybody can have their common sense with regard to deliberating and putting the facts to the law. I think this case is, like most cases, credibility. Who has credibility? Who has an interest? Who has credibility in the outcome? Everybody tries their own case, meaning attorneys, and everybody defends their own case. I told you in the very beginning that I think when you're done with the trial, at least I thought, that you think, why are we here? Why are we here for 2 days? Why is the court all involved, the prosecution, court report, all that, when there's true crimes occurring? Why are we here? You heard from their witness, Tyler Millward, their witness that works there but wasn't working that night, that he consumed about 4 drinks. That, he wasn't affected by it because he can multiply certain numbers or whatever, weight and all that, so he's okay. That he's had other people that they've asked leave or exchanged words, nobody's been arrested. In this case, somebody was called the police right away. If I was the prosecutor, if I was going forward as a plaintiff, and I wrote some notes down, I would have had number 1. Now remember, they're the ones with the beyond reasonable doubt, not me. They have. You chose to bring this case against somebody, you hired a lawyer, a trial, all that. I would want to have the best proof positive, especially since I have beyond reasonable doubt. Almost no doubt. It's not that far, but almost no doubt. I would have had the videotape. That would say a lot. No, it doesn't have audio, but that would say a lot. Or is the reason that the videotape is not here because it would have backed up what my client said. And what my client said was somebody came out of the bar or there in that group and hit 2 parts of the truck. They didn't even get out. Imagine that. Somebody hit your vehicle, knee-jerk reaction is usually get out unless there's a lot of people, then it's okay. And if I've been drinking, if I drive away, guess what? Drunk driving or visibly impaired. I'm gonna sit tight, especially what's going on and call an Uber or Lyft or whatever they call it. That video would have captured that. That video would have captured people coming up to the car, the truck. But because that's the best evidence, maybe for us it's not here. I don't know. All I can do is surmise. All I can do is guess, because guess what? I'm not the plaintiff. I'm not in the driver's seat. But I know that would have been one of my first pieces of evidence with the officer in charge. Go preserve that. It's good for 30 days. I get hired later just because of economic issues. He couldn't hire me till later. He even tried to do it. My client, after the 30 days, of course, after we talked. Another person that wasn't here to testify tends to make me think of this. If I'm prosecuting a case, I want a strong case because I'm dealing with somebody's liberty, dealing with somebody's criminal case. Why didn't I have Morgan Seacrest, I think that's her last name, that worked the bar, that made the phone call? Why wasn't she here? She could have said exactly what she saw happen, unless it didn't jive, unless it didn't fit in with him not acting on the bar and him having a conversation with her. Maybe somebody from outside came in, Tyler, came in and said, call the police. This guy's acting up or something. I don't know. But I do know, remember this part too that came out, that his friend was talking with one of the ladies, one of the young ladies that were in the group. I know one person was either married or girlfriend or whatever. And they were both walking outside, or they were outside in, you heard what the testimony was, but they were outside, the patio area. And there's a patio in the front of this. I've never been there. I think what happened, and I wasn't there, you weren't there, none of you, prosecutor wasn't there, she just goes forward with the case that's told to her. I think somebody got jealous or upset. I think people were drinking. Somebody didn't like somebody talking to somebody freely. You didn't have somebody there say, hey, I'm gonna report him. He's bothering me, he's hitting on me, he's putting his arm on me or something. You didn't hear any of that. There were no complaints. In fact, the ordinance says disturbing the peace of others. There was no fight, and you didn't see anybody in that group here today, yesterday, to testify, you disturbed my peace. You had somebody that's usually a bouncer there that had been drinking. And we know what happens when drinking occurs is it blemishes sometimes things of how you see things or perceive things. My client admits that he had drank, driver had drank. They were waiting for a lift. Then the Tyler Millward talks about the language that's being used. Bitch, and he's a bitch, or they're bitches. And I apologize, I don't walk around talking this way at all, especially the really bad words. My mom in heaven's by the way, down there, you say, Bill, ease it up. But you know what? It was taking place, and I didn't make the words up. You just don't act professional. You don't de-escalate a situation. You don't say, hey, okay, whatever, unless you're probably upset that somebody was talking to one of your ladies, freely exchanging words, talking. Maybe that's what was going on.
I don't know, not a mind reader, but I've experienced life a little bit, and I tend to read that way of what set it off. Then, oh, and by the way, he said, their witness from the bar said, well, I can say those words, or they can say those words, I didn't report it, because they have a First Amendment right. Hello? I'm looking at them, why are we here today? If you feel there's a First Amendment right to say those vulgar words, but that's for you and your group, but not for him. If that was even said by him. So there's two standards there. And then we get into the police officer. And now why you sort of can understand live, not something you read in the newspaper or something that's been cleaned up politically or whatever, live, of why things happen around the country, around the world. Because not only did the officer find it's okay to say F word or bitch word when nobody's done anything wrong, at least in front of you, they get out of the car and they see the blue and red lights on, that he didn't remember, but he remembered everything else, credibility wise. Start swearing at him, and not only that, but his supervisor comes in and condones the behavior without really even knowing the facts, without really looking at the video. He condones it. So now you've got a line officer that's brand new. He's on probation at that time, really brand new. So we're already educating that person that you can do it. Well, no wonder there's things on the world news. That's crazy. I'm not saying all officers are bad by far. I used to prosecute for Southgate many years ago. Fine officer, but this is not training. This isn't, it's okay. You can say, keep your fucking hands on the steering wheel. Oh, that's nice. Thank you. Okay. Especially if somebody's been drinking, you say that, okay? Give the award to both these guys, both of those. They got the award for de-escalating. He's supposed to be de-escalating. He's a professional, not intoxicated. But he's hyped up. He's going to take care of his body's problem with the bar. I'm not going to get into other issues that may have taken place or thought patterns. You can collectively as a jury ponder that. But then his supervisor says, yes, this guy's trying to talk to him as the handcuffs. I mean, if people were putting handcuffs on me, that's G-rated compared to what I've been. That's just not right. It's not in America. If you do it somewhere else, but not America. And he says, he's asking him, what did I do? What's wrong? And he says, shut the fuck up. Are you feeling okay? He's almost like antagonizing him to do something so he can do something. Spray mace or whatever. The guy is out. You saw him. Talking about credibility. I think he's got some pretty good credibility. Yes, at issue, he's a defendant in the case, unfortunately. Sometimes we don't pick and choose if we want to be a defendant. But he's a defendant and we're defending. But I'm not even without him. I'm using everything with them and what they lack. Why don't you have the outside tape? Man, that would prove a lot. It really would. It wouldn't look good if somebody in their group went out there and hit the truck tolls. And they stay inside. I mean, these people, talking about de-escalate, they're like, to me, some pretty nice people that I want to hang out with. So I want to thank everybody. Apology if I get a little emotionally charged. I've been doing this almost 40 years. And I just, if I go to trial on a case, which isn't very often, I truly, truly believe in it. I truly do. I don't just do it for the heck of it. And respectfully, I appreciate, just like the prosecutor said, all your time here taking on this case. If you were on trial or somebody alleged something to you that, hey, you hit me or something and the police forward it, you want yourself on the jury. You want somebody to say, yes, I'm glad I took the time out to be on the jury. So thank you very much. I respectfully request on behalf of my client that you return a verdict of not guilty. And just let my client continue on with his life, his 4-year-old, his work, and try to get this past him. Thank you so much.
Thank you. Ms. Taylor.
Last time you're gonna hear from me, and the fun things, a little bit. Mr. Close talked about why we are here today. We are here because Wyandotte does have an ordinance for disorderly conduct. The bartender clearly called 911 because she believed that the defendant and another person was antagonizing and threatening the patron. Defendant claims that the patrons and a girl started this ruckus, but at no time did the defendant nor his friend call 911. If someone was hitting or kicking my vehicle, absolutely, I would be calling 911. That did not happen in this case. Just because Mr. Clovis talks about the bartender not being here to testify, does not mean he is correct in his assumption. There is a reason that she was not here to testify, but not any of the reasons that he stated on the record. The defendant claimed, Mr. Clovis claimed in his closing argument, that the defendant was waiting for a lift. The defendant did testify that he was going to call for a lift driver. He did not. They chose to sit in that vehicle with the passenger window rolled down, having an exchange with the patrons outside. Again, the lift driver was not called. If this was my son, even as an adult, my kids know that if they behaved in this way, I absolutely would have looked at them and told them they were acting like an effing idiot. I use that language. May not be the greatest language to use, but it gets results sometimes. Based on everything you heard, again, I ask you to apply the facts to the law. The judge will give you the law. And again, the people respectfully request a guilty verdict in this case. Thank you.
Thank you.
All right, members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and a just verdict, based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I may have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that they are guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case, you decide on your verdict. You may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments and any commentary is not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. My comments, rulings, questions, summary of the evidence, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe, and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may be helpful for you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think that witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The evidence must convince you beyond a reasonable doubt that the crime occurred on or about June 16th, 2023 within the city of Wyandotte. When you go to the jury room, you will be provided with a written copy of the final jury instructions. In fact, you have that written copy now. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgments of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you, or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even myself, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty or not guilty. A verdict form listing the possible verdicts has been prepared. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard testimony from Officer Adam Grote and Sergeant Fitzpatrick, witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. The specific element of the crime, disorderly conduct, is as follows. The disorderly conduct charge occurring on June 16, 2023 in the vicinity of 116 Oak Street, also known as the Dot Pub in the city of Wyandotte, and reads as follows. For the charge of disorderly conduct, the complaint says at the stated time and place, the defendant, contrary to law, did violate section 153.001 of the Wyandotte Municipal Code. To wit, no person shall make, aid, or assist in making any improper noise, riot, disturbance, breach of the peace, or diversion tending to a breach of the peace. No person shall engage in any indecent or obscene conduct in any public place. No person shall gather with others for any unlawful purpose or to annoy or disturb others. For the charge of disorderly conduct, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant aided or assisted in making improper noise, riot, disturbance, or breach of the peace. Second, the defendant acted disorderly. The possible verdicts on the charge of disorderly conduct as the defendant Travis J. Allen is guilty or not guilty. Are the people satisfied with the jury instructions as read by the court?
Yes, Your Honor.
Mr. Clovis, is the defense satisfied?
Yes, Your Honor.
Okay. In just a few moments, I'm going to excuse you for deliberations. Prior to that, I'm going to excuse two of you from deliberations. This is the unfortunate part where you sat through all the testimony, but you don't get to participate in any discussions regarding the verdict. I want to point out that the persons whose names will be called have not done anything wrong. You just happen to be the names that are drawn from the box. As you recall from the first set of jury instructions that only 6 jurors can deliberate and decide this case. Officer Rodriguez, please raise your right hand. You solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors in this trial in some private and convenient place, unless ordered by the court, that you will suffer no communications orally or otherwise to be made to them, that you will not communicate with them yourself orally or otherwise unless ordered by the court, and that you will communicate to no one the state of their deliberations or the verdict they may have agreed upon. So help you God.
Yes, Your Honor.
All right, thank you. Members of the jury, everybody please stand. Members of the jury may now retire to the jury deliberation room to begin deliberations. All right, let's go back on the record in the matter of the city of Wyandotte versus Travis Allen, 231462. Okay, and so I'm going to inform we have a verdict, so we will bring in the jury. All right, for the jury. Please be seated. Juror in seat number 8, and you've reached a unanimous verdict. All right, if you can please, you can read the verdict. If you can please stand and read the verdict.
As to defendant Travis J. Allen, on the charge of disorderly conduct, we the jury find the defendant Travis J. Allen not guilty.
Just on behalf of my client, Your Honor, thank you very much for the jury and the alternate.
And then, as I indicated, Mr. Allen, you can stop at the window when we're done and confirm we have all your current information, and then your bond will be mailed to you. Okay?
Please, will you hand me my screen box?
Can you hear it? Can you hear it? Ma'am?
This is jumping day. Again.
Ma'am? Can you hear it?
No, no.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.